Mr. President, I guess I'm one of those extreme Republicans that believe that a child that sucks their thumb, wiggles their toes and fingers, feels pain, has a beating heart, has a functioning nervous system, has DNA that's different than the mom or the dad, is a baby. I didn't think that it was an extreme position to see a child as self-evident. That's a child. Now, I understand Americans are divided on whether children in the womb are convenient or inconvenient. And if they're inconvenient, they can be thrown away as medical waste. But if they're convenient, they're kept. I just think every child is precious. And I think every child should be honored and protected. So I guess that makes me extreme. The bill that I bring today is a bill that just looks at the millions and millions and millions of Americans who believe like I do. Many of them work in hospitals, and they joined the healthcare profession and got a medical degree because they wanted to save life. They want to be a part of protecting individuals at their most critical times. But they also have this real belief, that's a science-based belief, by the way, that a child in the womb is just like a child outside the womb. The only difference is time. 40 weeks ago, you were 40 weeks younger. That child in the womb at conception and the child outside the womb is just 40 weeks older, just like you're 40 weeks older than what you were 40 weeks ago. It's still a child. For the millions of Americans that believe like that, we've had conscience protection laws on the books for a long time. In fact, there are 25 conscience protection laws on the books in America right now. Many of these have not been controversial. In fact, if we go through the church amendments, when they were done, they protect the conscience rights of individuals and entities that object to performing or assisting in the performance of abortions or sterilizations against their religious beliefs or moral convictions. When that passed, almost 50 years ago now, it passed 92-1 in this body. It just wasn't that controversial. We understood that people disagreed on the issue of abortion, and why would you ever compel someone to be able to perform an abortion when their conscience objects to that? In 2004, Congress created the Weldon Amendment. It's on all of our annual appropriation bills. The Weldon Amendment bars federal government and state and local government recipients of federal funds from discriminating against healthcare entities that refuse to provide, pay for, or provide coverage or refer for abortions. It's not been that controversial. In fact, it was on the Consolidated Appropriations Act last year, which passed 92-6. This has not been that controversial to be able to honor the rights of individuals. Now, there are some things that have changed. Some of these 25 laws have not been enforced. In fact, these 25 conscience protections that are on our books right now are dependent on the executive branch to actually enforce those laws. If I go back during the Trump administration, they confronted California because California mandated that insurance providers had to provide abortion coverage. Well, that's not consistent with our law. And so the administration pushed them and said, no, you can't compel a religious institution that has a moral objection to abortion in your state. You can't make them buy abortion coverage and actually pay into that system, though California is. So the Trump administration said to them, no, you've got to allow those folks to have the option. That's the federal law. And that was in process of being enforced until this administration took the leadership, and Javier Becerra, who was the Attorney General of California, then moved to HHS and immediately dropped the suit against California, his old state. Curious. So the religious entities don't have any recourse in California because the executive branch won't enforce it. Let me give you another example. There's an employer, the University of Vermont Medical Center. They were pressed with a lawsuit against them for knowingly, willfully, and repeatedly violating the church amendments. They had nurses that were there that said, I have a conscience issue, I don't want to participate in an abortion, and the University of Vermont Medical Center would compel them to perform abortions or they would lose their job. It's in direct violation of federal law and the conscience protections. So there was a lawsuit against them to be able to have them actually carry out federal law. When the Biden administration came in, Javier Becerra immediately dropped that lawsuit. There was no settlement. There was no statement about it. Though it's federal law that you can't violate someone's conscience protections, they said, we're not going to enforce that federal law, though it was in the process of being enforced. So the question is, for religious entities in California or for a nurse in Vermont, where do they go? If the entity that's charged under federal law, 25 federal laws to be exact, to actually allow people to have conscience protections, if that entity says, we won't do it, what happens? Well, this bill's very straightforward. It just gives the ability for that individual to be able to press a suit for their own rights. If the federal government will not enforce the law, this allows that individual to step up and say, then I will then file charges that you're in violation of federal law for this, to protect their rights as a citizen. Quite frankly, it's not any different than what any other citizen would do anywhere else. That if they had some civil violation against them that was clearly in violation of their rights, they would be able to go to court and be able to say, my rights have been violated, here's the statute, and they'd have their day in court. That's not allowed currently in federal law. It has to be the executive branch to carry it out. And as we have learned, it is under the whims of the executive branch whether they're going to carry that out or not. Now listen, this is really not that controversial in America. The most recent survey that was done by the Knights of Columbus that actually just came out this week asked a question about conscience protections. It's a very straightforward question, and the answer came back. 75% of the individuals surveyed said that doctors and nurses should not be forced to perform abortions if they have a religious objection. Now, we're very divided on the issue of abortion, but our nation is really not that divided on the issue of conscience protections. This is, can an employer compel someone to do something that violates their religious beliefs or moral beliefs, and if they don't, they lose their job? That's the only question that's in this. And that's why I bring it to this body today. That's my simple request. Now, this body knows, and Senator Murray is on the floor with me today, knows full well of my beliefs about the value of every single child. I do look forward to a day that we are post-Roe as a nation, and the Supreme Court of the United States is not compelling every state to have abortions carried out that are elective abortions in their state. A post-Roe nation is not a nation that has no abortion. It's a nation where state to state, each state makes those decisions. I've brought bills dealing with everything from chemical abortions to 20-week pain-capable bills, dealing with Down syndrome children, dealing with Planned Parenthood, dealing with all sorts of different issues. This issue today is very specific, though, just about conscientious objectors. Should they be compelled to violate their beliefs by their employer? So as if in legislative session, I ask unanimous consent that the Committee on Health, Education, Labor, and Pensions be discharged from further consideration of S-401 and the Senate proceed to its immediate consideration. I further ask that the bill be considered read a third time, passed, and that the motion to reconsider be considered made and laid upon the table.
Is there objection?
I object.
Objection is heard.
To the chair, we will as a nation process through this in the days ahead. This body has very strict laws that cover my state and many other states for a lot of other things. In my state, if you go to build a building in the southeast part of my state, you have to do frequent inspections to make sure the burrowing beetle is not going to be harmed in that area, because it's considered threatened. If you're in the western part of my state, you can't build certain buildings in certain places, carry out certain farming activities because the lesser prairie chicken is there. If you're in California, they pour their water, their great water, out of the mountains into the ocean, because if they don't, it may harm the smelt. If you're building a bridge in Oklahoma at certain times of the year and a migratory bird puts up a nest in that construction area, you have to stop construction because migratory bird eggs are valuable, burrowing beetles are valuable, prairie chickens are valuable, smelts are valuable, but we throw children in the trash. We got to figure this out as a nation. And currently, we seem to be afraid to talk about it, or even to protect the rights of individuals who disagree about this in the workplace. We got to figure this out as a nation. With that, I yield the floor.